Hi, so today we are going to be talking about the legal risk of alternative maritime fuels, particularly in hydrogen under the Rotterdam rules. So the shipping industry is actually moving towards net zero emissions. Companies exploring cleaner fuels such as hydrogen and biofuels. Hydrogen is a clean energy solution because it produces no carbon emissions when used as fuels. However, it also presents significant safety risks in maritime transport. Hydrogen extremely low ignition energy. It has a wide flammatory range and is also complex carbon requirements. Hydrogen is classified as dangerous goods in maritime transportation. The shipping industry is encouraged to adopt environmentally friendly fuels, as carriers still have a legal obligation to ensure the safety and seaworthiness of the vessel. So this is where the legal framework of Rotterdam rules comes in. So I'll give you a brief preview of Rotterdam rules on the biofuel section. So it provides a modern legal framework regulating the carriage of goods by sea. Several of it provides a particularly relevant rules when ships adopt new fuels like hydrogen. First, in Article 14, which establishes the carrier's duty of seaworthiness. Under this article, the carrier must exercise due diligence before the voyage, at the beginning of the voyage, and during the voyage to ensure the vessel is properly crewed, properly equipped, properly suited, and seaworthy. Now, this means when a ship uses new fuel technology, such as hydrogen, the carrier must ensure that the vessel is technically capable of operating. On Article 17, which sets out the carrier's liability for loss, damage, or delay. So this means if the cargo is damaged or delayed during transport, the carrier may be held liable unless they can prove the incident occurred without any of their faults or the involvement of their faults. Now, Article 17 also includes certain defenses for the carrier. For example, Article 17.3 states that the carrier may avoid liability if the loss resulted from responsible measures taken to avoid environmental damage. Dangerous goods considerations. That key legal provision, Article 15 of the Rotterdam Rules. This article gives carriers the right to refuse to load cargo, destroy cargo, or render cargo harmless if the goods pose a danger to persons, property, or the environment. Since hydrogen is highly flammable and volatile, it falls under dangerous goods. This creates a legal tension. While governments promote green energy transportation, carriers may still legally refuse cargo if they believe it threatens their vessel's safety. Article 32 places obligations on the shipper, such as if the cargo is dangerous, shipper must inform the carrier about its dangerous goods. If the shipper fails, the fault will be held liable for any resulting carrier. Now let's look at some case laws. So I'm going to be mentioning and talking about the first case law, which is the Muncaster Castle. In this case law, that illustrates the current the carrier's responsibility in Riverstone Meat Co. Pty Ltd versus Lancashire Shipping Co. Ltd, the Muncaster Castle. In this case, the cargo was damaged due to defective repairs performed by the independent contractors before the voyage. The carrier argued that they should not be liable because the repairs were done by competent third-party contractors. However, the court rejected this argument. The court held that the duty to ensure seaworthiness is non-delegable. This means that the carrier remains responsible even if the work was done by independent contractors. The carrier must ensure that the vessel is seaworthy before the voyage begins, applying this principle to hydrogen or biofuel usage. If engine problems occur because of important fuel testing or compatibility, the carrier may still be liable, even if the carrier relied on fuel suppliers or technical experts. They must prove that due diligence was exercised to ensure seaworthiness. Now on to my second case, which is the Hong Kong for Shipping Co. Ltd. versus Kawasaki Kisen Kasha Ltd. The case addressed the concept of operational seaworthiness. In this case, the vessel experienced repeated engine breakdowns and delays due to an incompetent engine crew. The court held that seaworthiness does not only refer to the physical condition of the ship, it also includes the ship's operational efficiency and ability to perform the voyage. The court also introduced innominate terms, meaning that not every breach automatically results in termination or liability. Instead, the seriousness of the breach must be considered. Applying to alternative fuels, such as if hydrogen or biofuel uses cause minor performance issues, the carrier may not automatically be held liable. However, if the problem causes serious delays or cargo damage, the carrier be held liable under Article 17 of the Rotterdam Rules. Now, in my conclusion for the issue that we have discussed today is that the transition towards cleaner fuels, such as hydrogen, does create new legal challenges for the maritime law. The Rotterdam Rules attempt to balance two competing objectives in this case, which number one would be promoting environmentally sustainable shipping, maintaining strict standards in maritime transport. Now, carriers remain responsible for ensuring seaworthiness and operational safety, even when adopting new fuel technologies. The cases demonstrate that the duty of seaworthiness is strict and it is non-delegable. Operational failures can still amount to unseaworthiness depending on their severity. Therefore, although hydrogen supports global decarbonization goals, carriers must carefully manage the technical and legal risks associated with transporting or using their fuel, which is related to biofuels and hydrogen. Now, the Rotterdam Rules provide some flexibility for environmental measures, but they still place their primary responsibility on carriers to ensure safe maritime operations. Overall, in this case, moving towards hydrogen and biofuels does allow the goal of exercising environmental friendly options to reduce carbon emissions that are being spread around the world. But by doing this, there is a lot of factors to consider, such as the maritime laws, as well as the Rotterdam Rules that I have just discussed. And these articles are complex. They do contradict each other sometimes, and sometimes when these cases come up, they are put in a situation where a lot of factors that need to be seen, such as the fuels being used, the goods that are being liable, the contracts that are being used, and also if you look at the rules that set a standard in the maritime transportation world, it does cause a bit of a stir, and it requires a lot of understanding on how the laws can be used, and the trust that's being placed in these biofuels to be seaworthy, for example. And as what I just said, the issue that we've discussed has already been understood, and thank you.